Court of the State of Nevada is now in session.
Okay, please be seated, everyone. We will call our first case today, which is case number 63180, Shadowwood Homeowners Association of New York Community Bank. We have Mr. Riley on behalf of the appellant with Mr. Bohn, and we have Mr. Sass on behalf of the respondent. My understanding, the appellant's counsel are going to divide your time, and you're working out a schedule for the opening and rebuttal arguments. Okay. We will leave it up to you. Al, you got a timer up there at the podium then. So, Mr. Bohn, you want to go first?
Thank you, Your Honor. Michael Bohn for Appellant Gogo Way Trust. Thank you for granting the motion to hear this oral argument today. You decided the SFR case just a few weeks ago, which handled a big issue that was involved in a lot of cases in the district court. And there's 3 other issues which are still hanging around, which can all be handled with this case today. And those issues are the banks are complaining that they didn't get notice, or that they tendered payment, or that there's inadequacy of the sales price of the property. And the facts of this case, I think you can adjudicate all those issues today, should you choose. While I was preparing for the hearing today, I was reading Miller and Starr, California Real Property, and the cases cited therein. And they make some nice statements in there, like there's a public policy in assuring that foreclosure sales are final and assuring good title in the purchaser, and that there's a common law presumption that foreclosure sales are conducted validly, and that the comprehensive foreclosure statutes indicate are provided for parties with give the parties a quick, easy, efficient remedy, and to assure good title in the purchaser. And those are all good policy arguments which are important for investors such as my client, who all he did was show up to foreclosure sale, pay his good money, got a deed, and wound up in the middle of a lawsuit because of things that happened prior to the foreclosure sale. And the majority of these issues can be handled with just the interpretation of NRS 116.3166, and that has a conclusive recitals that are contained within the deed. I did, in my brief, cite a lot of California law and some of the California statutes. The difference between the California statute, which has the conclusive recital in its statute, and the Nevada statute, is the California statute has a requirement of a bona fide purchaser. There is no such requirement in the Nevada statute. All you have to do under 31166 is show up, bid, pay your money, and receive a deed. And those recitals in the deed of the default, the proper notices, are all conclusive as to the former owner, heirs and assigns, and all other persons, which would involve the banks.
What if the lender or the homeowner, let's say, had put a demand on the association for payoff information and a breakdown on how that's done, and weren't provided that, though, hypothetically? How does that implicate these proceedings, even though your client didn't have anything to do with it? But should that be considered in the calculus on how to resolve these cases?
Well, in the SFR decision, it was noted not once but twice that they always have the remedy of making the payment and going back for a refund a little bit later. And it kind of ties in with the other issue of inadequacy of sale price. This was ruled multiple times, inadequacy of sale price is not sufficient to set aside a sale. However, you also noted that the numbers are usually very nominal. And in this particular case, we're talking about a bank. We're not talking about an old widow. They were given the final number to come up and pay with. You know, they tendered an amount. The amount was rejected. They were given the final number.
Don't we have a factual issue about the amount, though? It almost like being a moving target in this instance?
Maybe, but with all due respect, it should not apply to my client. There's a presumption that foreclosures are conducted properly. If it goes to
Your
sale,
client stands in the place, so to speak. They're no better off than the HOA, so to speak, who conducted the sale and what they did. So to say your client, that's kind of the difficulty. I'm listening to part of your argument, and it's nice, but the real issue is how does it affect the HOA who conducted this and did the thing, set up the finances owing, whether they're actual allowable costs, so to speak, under the super priority statute, or whether we have issues. They attempted to tender. That was rejected because crossing in the mail was the new demand for more money.
the California authorities that I cited basically say that...
But is California applicable in terms of, is it verbatim the same as the Nevada statute?
The Nevada statute is actually more narrow. The California statute, you have to make a finding of bona fide. I know we discussed that a lot in my brief, but the Nevada statute does not require you to be a bona fide purchaser. All it requires you to show up for the sale, pay your money, and get a deed. And
since it does not mention that in the statute, then how do you give it those additional rights as a BFP? How do you get to that point?
BFP is not part of the statute, with all due respect. And the authorities do say that if there is any problem, you know, the purchaser has good title, and that's important for a purchaser. If there's an issue, you have to take that up with the foreclosure agent. I've burned my 5 minutes. I'm going to turn over to Mr. O'Reilly at this time.
Thank you very much. Mr. Riley.
May it please the court, counsel, Pat Riley representing Shadow Creek Homeowners Association. Just to follow up to Mr. Bohn's answer, this court laid out a procedure for what's supposed to happen in cases like this in Hamby Arrow Creek Homeowners Association. If there's a dispute over the amount that is owed to the association, the party is supposed to file a Nevada Real Estate Division arbitration, and if there is a risk of irreparable harm, namely a trustee sale like this, the obligation is to go into court and to either seek a temporary restraining order, file a notice of res pendens, something along those lines. And what happened here was the bank received a statement, but then didn't go into court until after the foreclosure sale.
But did the bank not, after they received a notice, attempt to pay? And as I said, we have this factual thing of a couple of days. A new notice was sent out saying the fees are now X. And I realize that comports with the demand requirement in the statute, but this timing issue.
There's a disconnect about how much is owed, and there is a factual issue. I absolutely agree with you. And the cardinal sin that the lower court committed was weighing competing affidavits as to whether one party was acting in good faith or bad faith, and then making inferences in favor of the moving party as opposed to the non-moving party. I think the threshold issue here, though, is the lower court set aside a foreclosure sale in part because it concluded that the cost of collection incurred by the association had been extinguished by the prior foreclosure sale. And the court misinterpreted NRS 116.31162 in doing so. And this is a question that has been hotly debated over the last 5 or 6 years. And thus far, the only state Supreme Court that has addressed this issue is the Connecticut Supreme Court in Hudson House Condominium Association v. Brooks. And what happened in that case was the Supreme Court looked at this statute and said, we presume that the legislature intended to accomplish a reasonable and rational result in enacting a law. And it didn't just look at the super priority lien statute in a vacuum. It looked at all the statutes. It said we've got a lien statute, we've got a super priority lien statute, and then we've got a statute that entitles the association to its cost of collection. And when we combine those together, we realize that assessments, the amounts of assessments are usually small. The cost of collection will usually exceed the amount of the assessments. And so we have to presume that there was a meaningful remedy created on behalf of the association.
Do we need to reach that question in this case? It seems to me the affidavits are not only conflicting but fairly ambiguous, and that it's arguable the question isn't inclusion of costs in the super priority piece, but rather the inclusion of costs in the lien itself, which is analytically perhaps different. I couldn't tell from the affidavits, and maybe you can elucidate this, what the breakdown was in that lien amount and whether there was a conflict in the facts or not as to that and what it was attributable to.
There is a breakdown of fees on page 242 of the joint appendix, which provides a breakdown of the fees. And what's particularly concerning about this is that if you look at just...
And how much of that, of the total, was attributable to the initial foreclosure by the bank? Because by the time your people went to total foreclosure, the bank had already acquired title, so it stood in the shoes of the homeowner, right?
That's not entirely clear from the record. If you look at the previous page 241, you see that there are 2 instances of a notice of delinquent assessment. There are 2 instances of a notice of default. What happened was the association commenced collection procedures and got close to the foreclosure, but then the bank foreclosed first. They happened to win the race to the foreclosure sale. And then afterwards...
So your client then started all over again, right?
When the bank didn't pay the monthly assessments after that, yes. And that went on for a number...
Right, so what's the breakdown of what was being foreclosed when the HOA restarted the foreclosure process?
That's not entirely clear from
That's what my question is.
Yeah. Yes, and there's a genuine issue of material fact there, and the problem is that we don't know the exact amount. But what the district court should have done is conducted a hearing in accordance with Nevada Administrative Code 116.470, which caps the amount of collection fees that can be charged by an association.
So what is your contention as to the amount that was owed by the bank?
The amount that was owed by the bank, as of the date of the foreclosure sale, it was...
What's your calculation?
It's $9,017.39. And
how do you arrive at that number?
Well, pursuant to pages 241 and 242 of the record, there is a breakdown there. Mm-hmm. The problem is that if there was a dispute over that amount, it was incumbent upon the bank to... Actually, they didn't dispute it. They received the final breakdown on February 14th and then didn't do anything for 8 days when they could have gone into court and sought a temporary restraining order if, in fact, they had...
Do any of those amounts, I just want to be clear about this, do any of those amounts include any sums that were accrued or owing before the bank's foreclosure?
Correct, yes. Some of those fees.
How much?
I can't say that to the court because the record's not clear.
Well, you've got the record in front of you.
The record, this breakdown, does not break it down by pre versus post-bank foreclosure.
Which is my point exactly.
No,
so if the court did that, if the court looked at this and determined that the amount that was owed was equal to or less than what the bank tendered, would you have a basis for proceeding with foreclosure?
Well, what we'd have to have is an evidentiary hearing first to determine that. Mm-hmm. But the point is, the bank knew that this foreclosure was going forward and it had the opportunity to stop it. And it did not make a dispute as to some of these fees are pre-foreclosure, some of these fees are post-foreclosure.
But it did tender an amount of money, some $6,000.
It tendered an amount that was not what the amount was owed as of January 23rd.
And what was the difference between those two amounts? How significant was that?
Approximately $2,500.
Yeah.
So it was a fair amount of money. Certainly worthy of going into.
But you're saying some of those fees could include post-foreclosure fees?
Absolutely.
You don't know?
Well, no, absolutely it could include post-foreclosure fees because the regulation 116.470 allows that.
Mr. Riley, you have about 3.5 minutes that you want to reserve.
Yes, I do. Thank you for your time.
Thank you. Mr. Sass, on behalf of the respondent here.
Thank you, Mr. Chief Justice. Justices, may it please the Court, Anthony Sassy on behalf of Respondent New York Community Bank. New York Community Bank was the owner of real property that was wrongfully foreclosed upon. Not only did Shadowwood attempt to collect amounts that it was not entitled to collect, but the manner in which the association went about conducting the sale was unreasonable and oppressive. In terms of the amount of the association's lien, a little over a month after New York Community Bank took title to this property, they recorded a lien for $8,238. In comparison, 1 month's assessment in this association is only $168.81. As Mr. Riley indicated, the amount they tried to collect were amounts owed by the former owner. However,
were they only 1 month behind?
Your Honor, at the time that New York Community Bank took title, the first assessment was not even fully due. They took title on May 24th. The first month assessment would have come due on June 1st. They recorded their lien, they sent their notice of lien on June 29th, not even a full month after New York Community Bank took title.
Wouldn't it be safer for the bank just to go ahead and tender up what they what is claimed as due and then come back later and try and figure it out, rather than take the risk of what happened here.
At the time the lien was filed, Your Honor, this was a bank-owned property, it was real estate owned. The bank was in the process of marketing that property. Typically, and that's the situation, any liens that are on the property, the bank doesn't immediately pay off. Instead, they wait till they have an owner and pay that off through the escrow. It wasn't...
Might be typical, but it's not very bright. So is it appropriate for the bank to just sit there and watch this accrue and do nothing? The statutes seem to compel some action by the bank, doesn't it?
Yes, Your Honor.
That's what counsel's arguing. And you've got at least a couple of remedies available to you. One, to seek arbitration through the Division of Real Estate, or to sue.
Yes, Your Honor. To address that, once the notice of default was filed and recorded, and it became clear that the association was going to proceed with foreclosure, it was at that point that New York Community Bank attempted to find out what amount needed to be owed. The notice of default provided an amount that was good as of August of 2011, but didn't record the notice of default till October. Obviously, those amounts are going to be out of date and stale. So days after the notice of default is recorded, New York Community Bank contacts Alessi & Koenig, the agent for the association, and for the first time asks, can we have a breakdown of that amount? They received no response. A month later, they send another request saying, can we have a payoff for that amount? Again, they receive no response. They go through other channels to attempt to find out what that payoff amount, that amount conflicts with what would seem to be the appropriate amount. And finally, in January, they send a third request saying, what is the amount we need to pay?
But didn't each of the notices that was recorded on that property, the notice of delinquency, notice of default, et cetera, state the amount that was required to cure at that point, or to pay off?
Well, as I indicated, the notice of default was already stale at the point they received it.
Right, but then there's a notice of sale that goes out that hasn't the updated amount, correct?
The timing of the notice of sale is sort of troubling because it comes in January after New York Community Bank has already asked twice previously.
My question was whether or not it stated an amount.
The notice of sale?
Yes.
It did state an amount.
And did your client tender that amount?
At the time it offered the tender, it did not, the notice of sale had not yet been recorded, so it didn't know. After it received the notice of sale, no, it did not tender a new amount.
What about this arbitration procedure Mr. Riley was talking about? Was that available to the bank? Certainly when the bank became owner of the property, there's no question it's a homeowner at that stage. Can the bank have done that as an effort to kind of head off the sale?
It would have been a possibility to do that. However, to speak to whether the bank even knew that remedy existed is unclear. At that point, the bank is acting on its own behalf. It's more than likely not fully informed of all the procedures that were available to it.
But counsel, whose problem is that? They're legally bound if they don't get a free pass.
But at the same time, looking at it from the bank, compare the procedures a bank has to go through before it completes foreclosure. The bank, in the bank's mind, is the owner of the property. It's engaging in foreclosure alternative discussions.
Counsel, this particular super priority liens are not unique to Nevada. They've been engrafted across the country. So to come before us and act as if the bank's not aware and the bank would not look into this jurisdiction is just not acceptable. It's not an acceptable argument.
As I said, Your Honor, the bank was considering foreclosure alternatives. It was in active discussion with the Homeowners Association's agent attempting to pay it off. Less than 8 days before, it for the first time received what the amount the HOA is claiming that it would accept to release the lien.
Mr. Sassy, would you concede that since the SFR case has been decided that this case does have to be reversed at a minimum and have the court sort out all the details here in these amounts, or do you disagree with that?
I would disagree with that, Your Honor. First, the super priority amount is limited to 9 months of dues. That's what the plain language of the statute says. That's what the UCIOA advisory opinion says. That's what the legislative history has indicated that it should be, and it's what this court said in SFR Investments, that it's 9 months of dues. At that point, the 9 months of super priority was $1,519.29. It did not include any costs for fees and collection that were incurred prior to the New York Community Bank foreclosure sale.
Would it include fees and costs incurred after? In other words, your client becomes the homeowner at the time your foreclosure deed's recorded. So they send a new notice of default or notice of delinquency, and it's followed with everything else. Is it your position that costs of collection are included in that lien, the 3116 paragraph 1 lien? Because the super priority issue is only in play as to the pre-foreclosure by the bank sum. So do you agree that costs of collection are included in the 31161 lien or not?
If I understand the question, it's does the super priority lien then tack on new amounts that were due by the bank?
No, well, not quite. Let's just say you've got a bank foreclosing against a homeowner on unpaid liens, and the homeowner owns the property free and clear. Can the bank get costs of collection, in your view, as part of that foreclosure on the lien? There's no super priority issue in there.
So just a lien pursuant to NRS 116.316.1.
Yes.
Yes, that does include costs and fees. No, I'm sorry. It does not include costs and fees of collection. It includes certain costs that are allowed under NRS 116.3102J through N, which allows them to collect certain fees associated with that. The one in particular that the associations have claimed includes costs and fees of collection is subsection K of NRS 116.3102, which allows the association to collect charges for late payment of assessment.
What do you do with NRS 116.31164 subparagraph 3, which concerns the proceeds of sale and their distribution? And the first of it says, it's 3C2, which says that before you get to satisfying the association's lien, the proceeds of sale must go to reasonable expenses, including a reasonable attorney's fees. How do you read that paragraph?
I interpret that to mean that the costs of conducting the foreclosure sale are separate from the lien. So as you read, it says before satisfying the lien, those are paid off. So if they're not included in the lien itself.
And so your position is, how could they go to the proceeds of the sale if they weren't analytically included in the lien somehow? In other words, if you get a sale for $1,000 and there's a $300 lien and $1,000 in costs of sale, the lien would get nothing, right? Because it would all go into the cost of sale first?
If the payoff that received from the funds of the sale was less than the amount of cost of collection combined with the amount,
yes,
then there would be a deficiency, and any other sub-junior lien would be forced to suffer as a result of the deficiency.
Okay.
Turning to the arguments related to Gogo Wade's status as a bona fide purchaser, first, the arguments raised before this court are not the same arguments that were raised before the district court. The district court considered simply whether NRS Chapter 645F applied to this sale. It does not. NRS Chapter 645F contemplates foreclosure sales conducted by mortgage lenders. It repeatedly references foreclosure sales conducted pursuant to Chapter 107 and pursuant to Chapter 14, non-judicial foreclosure sales by a deed of trust, and judicial foreclosure sales. Moving beyond that, even if that chapter did apply, Gogo Wade does not fit the definition of a bona fide purchaser given in the statute. The statute defines a bona fide purchaser as a subsequent purchaser who purchases from a foreclosure purchaser. In this particular instance, Gogo Wade was the foreclosure purchaser. The district court properly conducted as a matter of law that the statute was not applicable to Gogo Wade. Turning to the arguments that were presented to the court, in order to be a bona fide purchaser in Nevada, NRS Chapter 111 says that the purchaser must purchase the property without knowledge of an adverse right, title, or interest in the real property. The fact that Gogo Wade is purchasing this property from a trustee at a foreclosure sale, rather than directly from a homeowner, should impart knowledge on him that there is someone with an adverse right, title, or interest that may challenge the foreclosure sale.
So could there ever be a BFP out of a foreclosure sale then? I mean, anytime you have a foreclosure sale, there's a problem, right?
Under the statutes where they're allowed, then yes, but absent some authority granting bona fide purchaser protection to a purchaser at a homeowner sale, then no. Here, there is no...
So you're saying only under Chapter 107, but not a 116 foreclosure?
There is no reference to bona fide purchasers in 116.
Okay.
Is there any common law rule that we should be aware of or should, with trepidation, look at?
I would point, Your Honor, to the Long v. Town decision that was cited. In that, it was a homeowners association sale that was conducted, and the question before the court was whether or not to overturn the sale. The court there decided not to overturn it because it found that mere inadequacy of price, with nothing more, was insufficient to overturn the sale. However, it added that if it was combined with fraud, oppression, and unfairness, that it implied that it would have overturned the sale. There was no evidence of fraud, oppression, or unfairness. I would submit to you that here there is, given the discrepancies in the price, the refusal to provide payoff demands when they were asked, does constitute fraud, oppression, and unfairness.
Should we take into consideration the bank's disregard of its responsibilities to avoid this whole problem in assessing unfairness?
In assessing the unfairness, it's to what...
I mean, generally speaking, when we look at equitable relief, we examine the impact and the conduct on the part of both parties in the lawsuit. Seems like you're asking us to ignore completely steps the bank could have taken to protect its own interests here. Shouldn't we consider that when examining unfairness under Long versus Town?
Considering that, we also have to take into account that while the bank didn't take every necessary step that it could have to protect its interests, it was actively taking steps to protect its interests. It was seeking out a payoff demand. Before the notice of sale was recorded, before the foreclosure was conducted, months before, it was asking for a payoff demand. It was actively attempting to protect its interests. Whether or not it took every available remedy or chose the best course, it was taking some action.
Your client did tender over $6,000 or so.
That's correct, Your Honor. It tendered an amount of $6,783.
So why wouldn't you argue that if the amount were recalculated by the trial judge and based on a determination of the amount, the super priority portion that existed after your client took title, and the amount of accumulating homeowners association fees and even collection costs post your acquisition of title was an amount less than $6,000, your client would have satisfied the requirements expected of them under the statute.
That is one of the arguments, Your Honor, is that we did tender an amount equal to what they demanded. They sent a payoff demand.
So would the court then, in that circumstance, be in a position to assess the unfairness, recognizing that your client had tendered an amount that was at or above the amount that was actually owed?
I think, Your Honor, the amount that the district court determined was the amount of the lien is the correct amount. The district court determined that the lien was based off a super priority amount. Given that the lien was recorded before the full amount was due to Shadowwood for the amounts that the New York Community Bank owed, that lien was for the super priority lien amount and that amount only. Had New York Community Bank been given the opportunity to pay off that amount earlier, many of the charges that would have been incurred by Shadowwood in collecting assessments would never have been charged. So
that's why I asked you before, do you think it needs to be remanded for the district court to sort this out? exactly the issue that Justice Hardesty just raised.
No, because I think the appropriate amount of the homeowner association's lien was $1,519.29. The amount of the super priority piece that survived from their community.
Okay. Thank you.
And that amount would exclude any post-acquisition of title collection fees, correct?
That was charged by Shadowwood.
Yes.
That would have been a separate lien that would have had to be re-recorded. Under NRS 116.31164, an association cannot send a new notice of lien until 60 days after the delinquency has passed. That was the notice of delinquency that was recorded on the property post New York Community foreclosure sale was only a little over 30 days. So the only amount that could have been included in that lien would have been the super priority piece.
Okay, but on the other side of that, no homeowners association fees had been paid for several years. Isn't that correct? So when you say that, you're just saying post your client's acquisition of title.
It's true that the former owner had been delinquent for a number of years. I believe the delinquency dated back to 2008.
Yeah.
But the amount that was owed by New York Community Bank had not been delinquent for more than 60 days at the time the lien was recorded. If that lien were to include anything more than $1,519.29, that would have been a violation as well, since no notice of lien was recorded after the delinquency was more than 60 days old.
Great. Thank you very much, Mr. Seth.
Thank you.
Okay. Mr. Bohn?
Thank you. I'm going to try to be fast because Mr. Riley has something else he wants us to tell the court here. As far as reversal back to the district court, I would ask this court to keep in mind there's two appellants here. My client was the purchaser, and I would respectfully request that the court hold that my client, as the purchaser, with those conclusive recitals in the deed, has good title, which should not be
That's the
said.
primary basis on which you rely if the court rejects the application of 645.
The district court in this particular case made no findings
If
whatsoever.
this court rejects the application of 645, what is the basis on which we extend BFP status to you?
NRS chapter 645?
Yeah.
645 doesn't apply,
Okay.
frankly, but 31166, which has conclusive presumptions, does apply, and in my opinion takes the bona fide purchaser issue out of the question because
Did that statute specifically overrule Long versus Town?
No, I think they both work in harmony with each other.
Well, then at least Long versus Town leaves open for a trial court the requirement to examine fraud and unfairness, does it not?
That would be correct.
So if this court were to determine that there are factual questions concerning the subject of fairness, what elements should this court direct trial courts to look at when assessing fairness or unfairness in these foreclosures?
Well, the fairness and unfairness would be done with the foreclosure trustee and not a bona fide purchaser who comes and just tenders money. The findings issued by the court is correct. There's no findings whatsoever.
Nothing in the Town case that says that you look to the trustee. The Town case says that the trial court will assess whether or not there was fraud, oppression, or unfairness. So how do we direct the district courts and all this litigation that has taken place to assess the subject of unfairness in determining whether to set the sale aside?
If there was fraud on the part of a purchaser at a foreclosure sale, that would certainly be an issue.
I'm not asking about fraud. There are three words used in that case.
Okay.
And you have acknowledged here today that the statute, which seems to bar any consideration of this, leaves open that analysis under Town.
If there is fraud or oppression or irregularity, then that's something that should be looked at. But there's no evidence here as far as my client is concerned, and there's no findings on the part of the district court judge as to anything wrong my client did. There is a conclusion of, there's no finding of fact. There's a conclusion of law that my client is not a bona fide purchaser with nothing to support it.
Okay.
And I'm going to step aside and let Mr. O'Reilly.
Thank you, Mr. Bohn. Mr. Riley, we'll give you an even 2 minutes here. We kind of went over on Mr. Sassy's comments. We're trying to even the time out. So
Thank you.
take 2 minutes and do your rebuttal.
I appreciate it. 3 weeks ago in the SFR case, this court cited with approval to an article by the report of the Joint Editorial Board for the Uniform Property Act. I would note in that case that while they do not decide the issue of exactly the amount that's in the super priority lien, every example that they cite to provides that the cost of collection are part of the super priority lien and survive the foreclosure sale and are not limited to a 9 times or 6 times monthly assessment amount. I'd like to point
But the
that.
2008 amendments add that into 3116 that Nevada has not adopted. So what say you to that?
I would direct the court back to Hudson House because in footnote 4 of the Hudson House case, what happened was the Connecticut legislature added in an attorney's fee cost provision while the case was pending, and the Connecticut Supreme Court said, wait a minute, that's a clarification. It was always in there.
So clarifying, not changing?
Exactly.
Well, that analysis in Hudson House isn't very satisfying. What authority did they rely on other than the court speculating about what the legislature was intending?
I would direct the court back
I mean,
to
that's rather risky business for us to speculate.
a basic maximum statutory construction is to not allow for unreasonable or absurd results. And what we have here, if you cap this...
So the absurd results are in the eye of the beholder here.
I suppose they are. You're the beholder, I guess.
Yeah, right. Judge Posner would say that some of these statutory construction maxims are just fool's folly. On a separate question, though, back to the Justice Pickering's comment, what's the basis, since our legislature didn't amend this and take this 2008 amendment, what would be the analytical approach if we did an opinion here that would incorporate costs into this figure?
I would ask the court to consider whether they were already there.
Go ahead.
Go a little longer. The statute says that the lien is senior to the extent of assessments that would have accrued but for the default. It would have been very easy for the legislature to say in an amount not to exceed 9 months worth of assessments. The legislature didn't do that. To the extent of is a key phrase. Now, if the association does nothing, it's 9 times monthly assessments. But if it's undertaken collection activities and costs, it needs to be compensated. Part of that mathematical equation, 9M, you need to add in the collection costs. Otherwise, the association's not being made whole. It's a right without a meaningful remedy. That's how I would approach it. I would also look at NRS 116.1114. All of these statutes are supposed to be liberally administered to place the aggrieved party in the same place it would have been but for a default. So we're not looking at a strict construction. We're looking at a broad, liberal construction in an attempt to put the association in the same place it would have been, at least for that 9-month look-back period. And this is a look-back period. So if the court does remand the case to the district court, the instructions are going to be very important. I would say that there's no commercial reasonableness standard based on SFR. I would also say that the court needs to instruct the lower court that costs of collection are part of the super priority lien and are not limited by that mechanical strict 9 times monthly assessments figure. The assessment portion is capped, but not the non-assessment portion.
If this court rejects the notion that collection costs pre the bank's acquisition of the property are included in the lien, was your client required to file a subsequent lien for accruing costs post-acquisition?
I don't believe so, although it's important.
Why not?
Because this is a statutory lien, and so it's automatic. From the moment that the assessment is incurred, there is a lien upon the property. So it doesn't necessarily require a notice of lien. But at page 221 of the record, on June 29th, notice was absolutely given to the bank. There's a letter saying, we represent Shadowwood Homeowners Association. We know you're the new owner of the property. This is the amount that you owe us. And it's important to note in this good faith, bad faith analysis that the bank doesn't respond to this and other notices for several months. Again, we go back to this kind of lower court weighing affidavits, which is inappropriate.
Okay.
One more question,
Justice Pickering.
if I may. Do you have any comment on 31164 sub 3 C2, which is the distribution of the proceeds of sale, and how that should factor in, if at all,
Yes,
into our analysis.
It's important because if you cap the super priority lien at 9 times monthly assessments, you have these disparate results where the association, if they happen to foreclose first, they get all their collection fees and costs. But if a bank happens to foreclose first, it doesn't. There's no rational reason for that difference. And then what do you create? You create a race to foreclose. I would hope that the public policy of the state would not be to encourage more foreclosures.
And last, I could not find the CC&Rs in the record. Both briefs referred to a clause that supposedly entitles the HOA to attorney's fees in the event of a lien foreclosure. There's no record cite for that. Is it in the record anywhere?
I've only been on this case for a week. I did not see it in the record. I don't think it was disputed that
Right.
those fees.
But as far as you know, the CC&Rs aren't in the record.
Yeah.
May I have one? And
Yes.
it's a short one. Basically, what I'm getting from you is the district court doesn't have any discretion in assessing the reasonableness of the fees and costs. Is that your position?
No.
Okay, and so let me have you do this. I would like you to address the judge made a finding of or a conclusion of law, number 10, in which she specifically said that Shadowwood the agents were attempting to profit off of the HOA foreclosure by including exorbitant fees and costs that would not be used as a basis for the foreclosure sale in this matter. So that to me seems like a very discretionary statement.
And the problem with it is that the regulation promulgated by the Commission back in 2010, NAC 116.470, places very specific caps on the amounts that you can charge. So it's not a question of trying to gouge. She simply should have looked at that regulation and gone through with the parties what was capped and what wasn't.
But okay, I'm not going to. That's all right.
And actually, let me back it up a step. The real problem here, which is ultimately what the court is going to decide, is that the bank let the foreclosure happen and then filed the lawsuit first. Had it gone into court prior to the foreclosure, you could have sorted this out in advance. And the problem with an affirmance in this case is that it opens the door to let anybody who wants to challenge on a post hoc basis the foreclosure, even by a penny, can get that foreclosure set aside. And I promise there will be many, many more lawsuits headed to the way of the district court. This was not an 80-year-old widow. This was a bank. They had the means and the opportunity to go into court, file a lawsuit, a notice of pendency of action, a TRO. They didn't do it.
Okay, thank you very much, Mr. Riley.
Thank you for your time. I appreciate
Thank you
it.
both for your excellent arguments and briefs, and we will take this case under submission. Okay, let's go ahead and call our next case, which is, parties can come up to that.